visible?
Okay, so we shall now start. Every participant here is present now. So
Yes.
first of all, I would like to extend a warm welcome to each and every one of you who has joined us today for this AECCI's exclusive AMA session on the topic of importance of enforcing contracts in international trade. And we are very glad to have this opportunity to engage in this insightful discussion with all of you. Okay, so before proceeding further and introducing ourselves, I will just take a few moments to introduce my organization. So Asian Exporters Chamber of Commerce and Industry is a dynamic chamber of commerce which is a recognized trade body by Ministry of Commerce, Government of India. And AECCI has been actively involved in promoting and facilitating international trade, providing valuable resources, and as well as fostering connections among professionals in the industry. We also offer our dynamic and active services to our members, and thus we have initiated this AMA sessions wherein our members can easily hear us and share their query with us if they are facing any challenges. So, because we understand this critical role that contract enforcement plays in ensuring the smooth functioning of international trade, our commitment to our members is to excellence with our expertise in this field and with as well the expertise of our team and of the panel of our arbitrators. And we have allowed this to successfully assist businesses in navigating the complexities of cross-border transactions. And further proceeding with, my name is Tehri Mullah and I'm representing AECCI as an executive director. I would ask my co-host, Ms. Pooja, to please continue with her introduction and please proceed further with your questions. Please.
Hello, allow me to introduce myself. I'm Advocate Pooja Bajpure. I am an advocate with AECCI legal team. I handle their South and North America region. So I've been associated with AECCI since a long time. So I've handled and even discussed lot of international disputes, even helped negotiate contracts, international contracts. So today we will be discussing more about the same, that how international contracts should be enforced and how importer and exporter should be made aware of the importance of the contract without getting an hindrance in the businesses. Because at times what happens is while we are negotiating on the terms of contract, there can happen that it can put a strain to their trade relations. So while enforcing contracts or executing contracts in international trade, we have to understand and make sure that the business relations between India and other countries are safeguarded. Because if that is developed, inflow of foreign currency will be more in our country. So we have to keep a balance to even tell them about legal opinions, but also see to it from the business perspective.
So I would ask Ms. Rupali to please start with your introduction. Okay, so our audience, our national, international audience can also know who you are and what your expertise are.
Thank you so much, madam. Myself, Advocate Rupali Akolkar. First of all, I'm grateful to the organization and to respected madams for giving me this opportunity to be part of this session. And in fact, it's a learning for me also because we take a lot of efforts to prepare. Of course, we have the experience working with these contracts, but then especially preparing for this session was something, which was really interesting. Myself, I have around 10 years experience. Most of it has been in litigation related to commercial contracts, international law in the sense of IP, intellectual property rights, trademarks. I've also been representing government organizations, especially the railways in arbitration matters, and also for commercial contract related disputes, tenders related disputes. I've also been working on setting aside the arbitral award. So major experience has been based on the Arbitration and Conciliation Act and related litigation.
Okay.
Other than that, I have been into patent, trademarks, intellectual property rights. I've been in Japan for a few years, and that experience has helped me with the international aspect of law. It's not just the IP related, but contracts and the import-export part related to LEDs and new technologies which are coming up. So that is my background.
Okay. Mr. Anand Chowdhury, could you please introduce
Yeah,
yourself to our
yes.
audience?
Good noon, everyone. I am Anand Savgai. I am ordinarily practicing on the civil litigation side and have been in practice since last 27, 28 years. And I am mainly on litigation side. And since last 10, 12 years, I have concentrated on arbitration side also. So arbitration is purely a contractual dispute. And I am into that since last 10 years, about 10 years. And that's now since the center has been commenced by this arbitration center has been commenced by the AECCI. I am associated with them.
Okay, sir. Thank you so much. Mr. Jafar, could you please introduce yourself and what are your expertise? And please proceed with your questions as well, which you would like our arbitrators to answer.
Okay. Thank you very much, and thank you for giving me this opportunity. I'm Jafar Al Khair from Syria. I graduated from Tishreen University, Faculty of Law in 2014, and I joined the Syrian Bar Association as lawyer. I trained for 2 years as a trainee lawyer. After 2 years, I submitted as a dissertation to obtain the title of professional lawyer. So after I get the title of professional lawyer, I practiced law for 3 years also. So totally, I have 5 years practice in law profession from 2014 till 2018. After that, I decided to pursue LLM course outside Syria and decide to travel to India and pursue LLM course in KIIT University in Orissa, which I spent there 2 years. During that course, during studying that course, I focused on international arbitration law and other method. Actually, my interest in arbitration law, international arbitration law, and different kind of national arbitration law does not start from India. Since I was practicing law profession in Syria, my practicing in law field make me feel how much international arbitration law and other method is important. So because there are many problems, many obstacles here in India and also in Syria and many other countries, we can find also that these problems are same in even in different countries.
Correct.
So it is not like I don't want to go into detail. Let me continue my introducing myself. So after I finished LLM course, as I told you, I focused on international arbitration law. My dissertation in LLM course was related to international arbitration law. The title of my thesis was Recognition and Enforcement of International Arbitrational Award under the New York Convention 1958. After that, I focused in the practical field. I want to enter into practical field and practicing international law as arbitrator and whatever any also duties I can provide in international arbitration center. This is was my, we can say, my dream or my plan. But when I graduated from LLM, it was 2020, and what happened in that year: coronavirus and pandemic and economic situation in every country of over the world was like
Right.
bad, let's say, and no employment, no jobs opportunities. So that is why, and everything was closed. That is why I decided to continue PhD program. So right now I am residing in Himachal Pradesh, Solan, and Shulin University, pursuing PhD program, also specialization in international arbitration law and other methods.
Okay, Mr. Jafar.
Okay.
We got your
Um,
introduction very well. So, because this timing is just for half an hour, we can continue with this.
okay, I'm sorry. Okay.
No, no,
Because
no.
No
it is
issues.
first time,
No
it
issues.
is first time we are meeting you, so that is why I want to give like
Yes, you would
very
like to
wide
introduce
statement
yourself.
about.
Yes, exactly.
Thank you so much.
Okay, so we have been receiving, ma'am and sir, we have been receiving frequent questions from our members, okay, regarding this one. Like, as I told you that we haven't started coordinating with clients, okay, we have started incorporating our clause in their agreements. We have been now frequently receiving these questions. Like I have, whenever I call them, they have, certain questions like SRQ, YAQ, there are many various types of questions which sometimes make no sense, but we have to answer them and explain them. Okay, so we have noted down few of these questions which my team will ask you. Okay, so starting with the Pooja, please.
So ideally, first question every member has is why is it necessary to get into a contract? Because most of the time what merchants do is exporters, they will just have a verbal contract. That's it. And they will start with the dealing. So their more important question is why is there a need to get into contract? Rather, they are more afraid that if they get into legal contracts, they might lose the business.
Okay,
So ideally, this is their query which we have received.
okay.
Can I?
Yes,
Yes,
Yes.
Absolutely.
The thing is, usually the trading transactions or trading dealings are usually done as the standard business practices.
Yes.
And as long as the relations are smooth and the things are going in its own, means as per what they were expected, the things are going in that direction, everything is okay. What you are supposed to respond to are the person who is raising such kind of queries, that this is putting down the contract into writing is nothing but whatever has been agreed in the transaction between the two parties, that is to be just reduced into writing for the sake of, first objective is not to misunderstand each other. What we have agreed, I say that I am selling you one banana and you perceive it as something else. So what we have agreed is has to be reduced into writing. In what manner the trade and business is to be transacted is, means there are many, whatever the gray areas between the conventional dealings without a written contract are supposed to be removed, and those are for as and by way. First is mutual trust building ho jata hai. Second objective is to remove misunderstandings. Third is what we are supposed to deal with, means what is my role and what is the other side's role, that we have to ascertain, and that is to be figured out. Where do we figure out each and every time? We don't go back to the what is the standard business practice. Okay, yes, that is before me. So that is the objective. And the last but the most important objective is what if in case of dispute, because every gray area is taken shelter to when there is a dispute as to execution of my part of contract and your part of contract. It happens only in that case that no, it wasn't agreed. The query comes ki, nahi, nahi, this wasn't agreed. That was not the part of the deal. So that is why, in order to avoid this misunderstanding and situation, and in order to provide a remedy or say amicable remedy also, means amicable mutual understanding also, whatever dispute arises can be settled out, because this is all in the interest of parties. That's all.
Okay, correct.
Addition to what Sir has said, I would like to state here that here, I think those traders who are coming to you are working on the international sphere. Right? So it's a cross-border transaction.
Yes.
So they have to face different laws, different cultures, geographical area is different. Then also the interpretation of law is different. Sometimes there are language barriers. If there is no written contract between the parties, the same term could have a different meaning.
Right.
Like as Sir said, a banana may mean something else to him. So in that case, we need to have a written agreement to set up the expectations right. Also, it gives sort of a credibility or an assurance that, okay, we are on the same page, we are understanding the same things, and the same way the business is going to be transacted, that the delivery is going to take place at a scheduled time. And this is the way, in case there is a breach of any term, this is the remedy. So in that also the ADR, the alternate dispute resolution mechanism, can come in if the parties so desire. So I think that is the reason why a written agreement or a contract is necessary, for especially for international transactions.
Yes, sir.
Yeah, ma'am was saying ki, what is agreed between the parties. So that is what Contract Act, there is a novice term. It is consensus ad idem. So what is agreed by parties voluntarily, that is to be reduced into writing, nothing else. Whereas parties are signing something or written contract, there's nothing to fear about it. In fact, it is for their benefit.
Right.
That's it. Yeah.
Correct.
So do you think there can be any obstacles which can arise while executing the agreement between cross-border countries?
Yes, there can be.
They are fearing that अगर problem होता है तो क्या? मतलब while executing the agreement, so they are basically hesitant to get into agreement, thinking that what if the other person doesn't do business with me? So I wanted to know the opinion of what obstacles can arise while executing an agreement.
Obstacle is what you can say is private international law. The conflict, the obstacle could be the only, they think, conflict of laws. Something else is provided in our Contract Act, some remedy, means even if the contract is not written, say for example, parties are domestic Indian parties and they are dealing with each other and the contract is not written and the dispute arises. The court will ascertain the contract between the parties from the communication, correspondence and the dealings. And court will remedy their grievances or order a performance if it is sought, or pay the damages if whatever the case may be. This is what the Indian law is. So where the parties are international, the party sitting in India will perceive the contract or the law applicable to the contract as it is applicable in domestic market. The party sitting cross-border will see for them there may be some different terms of provisions of law. So this is what is conflict of laws, as is said in private international law, because where two same kind of dealing is dealt with in different perspective, or different remedies are provided under different laws or different jurisdictions. Indian jurisdiction, something else is provided. In French jurisdiction, this you'll find in recording of evidence in Indian law for civil dispute in courts, or even in for the purpose of arbitrations. Usually we seek guidance under CPC and Evidence Act.
Right.
And in French jurisdictions, there is something else. Now here in India, I'm giving you an example. Here in India, what we do, there is a provision of cross-examination. That is across immediately. The cross-examination is across and oral. In French jurisdiction, you will find something different. Everything is on affidavits. Questionnaire is given in writing and then questions are replied. This is what the cross-examination was. These are, for example, this is conflict of jurisdiction, so procedural law applicable to the in different jurisdictions. So that is why you have to decide while dealing between the cross-border parties, the parties will have to decide in case of dispute, which law will prevail. Contract, of course, the contract will prevail over everything, but the contract has to be within the four corners of law.
Okay.
So contract cannot be illegal. Contract has to be within the four corners of law. So which law? So that also, if parties are foreseeing some dispute or they want to rule out the possibility of any kind of gray area, then parties should also provide that which law should prevail.
Okay.
That is why the parties are sometimes hesitant. now I'm dealing with some Arab country, some person sitting in Arab countries, or some person sitting in Europe, or some person sitting in where common law, or that is what we call the law originated by British legislation is common law. Common law is not followed, and French legal system is followed. Then there is some there are some areas where the parties might hesitate, but these things can be worked out, negotiated, and can be mutually decided.
Okay.
Here,
Great.
if I can add something,
Yes. Yes.
if you allow to me,
Yes.
okay, like actually as a principle, that a contract to be written is not compulsory. This is as a principle, means if I signed an agreement, oral agreement between me for and you, here, like if I and I suppose this agreement, this oral agreement didn't some one party didn't act his perform his duty regarding this oral agreement. Here, how can I prove this agreement? This is the main issue. The main issue to write a contract is play as proof
Mm.
to establish what the rights and what the duties of different parties. This is most important. Here, likely related to international arbitration law. If now I suppose a client come to my office, to my law company, and told me I want to make a contract and your advices, but I don't want to write this contract. To I want this contract to be oral. I don't want to write. Suppose that, okay? So what I should say here to him? I should say this is not in your favor. This is not in your interest. You will not get benefit from this way of making your business or making your agreement, because you have to prove
Mm.
your rights, and other party you have signed with him also has to prove his right and the duties of both of you. So this is most important. I should shed the light or pay his attention about how much agreement to be written is important to prove. Why I said this is related to international arbitration law, because when we signed a contract, there are two ways to resort to arbitration. First way, to include the contract and arbitral clause, including the contract before the dispute arise.
Mm.
We suppose the dispute will happen in the future and includes an arbitral clause, including the contract. So this way, before the disputes happen, means the party expect that the dispute, if a dispute happen in future, there is an arbitral clause included in the contract. Another way is, if there is no such arbitral or arbitration clause included in the contract, the parties of the contract, after the dispute happened, they then sign a new agreement, a separate agreement related to the arbitration. Here, if that client which I talking about, which come to my office and ask me not to write the contract, which I said I should pay his attention how much this important, and also I should pay his attention how much also important to include arbitral clause during that contract, as we have agreed about it, that this contract, this written version of contract, we can say, is play as a proof. So why we didn't insert arbitration clause or arbitral clause including the contract? Because with this in practical field, this is a problem. When we say to the client, we want to include, it is better for you to include arbitral clause if there is a dispute happen in future, so you can resort to arbitration. So here, client, maybe some of them will not happy with this, or we don't have knowledge, we don't have experience about arbitration, so maybe refuse. So my point is, as that written version of the contract play as a proof, also arbitral clause to be included before the dispute happen, if it will happen. So this is also, the client should understand this point, how much is important.
Very clearly, you have explained your point, Mr. Jafar and Mr. Chowdhury, sir. Okay, and
So, what is your opinion if the business says have to adapt these things to convince? What do you think should be the strategy?
First of all, you need to have an awareness created between the parties. Like the traders who come to you, they need to know the importance of having a written contract. There is a hesitation because there's a fear that they would lose business.
Right.
And it's like the deadlines. So they want to have the shipments delivered, they want to get money fast. So who would go into the legal aspects? And then again to convince their other side saying that you need to abide by these terms and conditions. So they fear that if we dictate terms, the other party may not accept. So
Right.
because of that, there is hesitation. So the important thing here is to create awareness, maybe to show them the existing cases where parties have not entered into any contract or have entered into an improper contract and are facing dispute resolution or litigation. So the losses they have incurred would probably help these people to understand that the necessity of a written contract is so very important, also very high. So if that one is the awareness which needs to be created. Secondly, if we could have standard templates which we could give with probably with your membership form saying that if you're going ahead with the international relationship trade or something, then you need to have this sort of an agreement with your other side. So the moment they contact the other side, they say, see, boss, you need to fill up this form and this is the way we are going ahead. So that would also help to streamline, and that fear itself would go from the initial stage because they know that the organization taking care of all the legal aspects. There's not, they don't have to break their head over each and everything. And then you could also help them understand the importance of ADR or other mechanism. And then choosing the jurisdiction. Sometimes the language barrier, I have faced this in my Japanese clients, where the contracts are in Japanese. And then the jurisdiction is Tokyo or Osaka or whichever, like the local jurisdiction. And then it becomes very difficult for a person who does not know the language to appear there, to be represented there by a local lawyer. So in such cases, getting the translation of their contract and then also to mention in the contract which version would be valid of which language, whether the Japanese language or the English language. So all these things need to be explained to the prospective trader who's going to enter into the contract. And if they understand that importance, I think half of the things would get solved at the initial stage only. I mean, disputes wouldn't arise, or if they arise, they would be, easy to resolve.
Okay.
exactly.
Now,
Yes, sir. Continue.
yeah. I'm sorry. Did I interrupt you?
No, sir.
I just wanted to add something, because see what happens when the parties are hesitant to enter into written contract and you have to convince them. There is one important benefit attached to written contract is that you can if you have to provide a dispute resolution mechanism, you have to do it in by way of a written contract, because in all jurisdictions globally, everywhere, arbitration clause has to be in written, and it has to be an arbitration agreement. So that can be incorporated in the contract. And why dispute resolution mechanism is necessary so far as international cross-border trade disputes are concerned, because as you rightly said, the clients are hesitant because of so many things. The thing most important is whether the other side will sign or not when I am insisting for a written contract, because there would be a gray area which contract act or which law will prevail in case of dispute. So in that case, now, so far as dispute resolution mechanism is concerned, almost each and every nation globally has accepted either New York Convention or the Model Arbitration Act, which our latest 2015 Act is on that lines only. 1996 Act is on those lines only. So the model law is followed almost everywhere, and New York Convention, which provides for execution of international awards, this is the most important advantage, because parties making cross-border contracts and dealings, 99 dealings succeed and they earn handsome profit. And if one dealing somewhere something goes wrong, the whole business is means
Right.
collapsed, and everything what was earned in last so many years is gone in just one delay. And in order to avoid that, you have to provide for dispute resolution mechanism, and that can be provided only by way of written contract. And फिर इसके लिए जब written contract कर रहे हैं, तो why not provide for other things where mutual understanding can be better built up.
Yes,
This
exactly.
is the way how we should go ahead with the parties.
Exactly. One thing here, Mr. Rupali, which you said is whenever a new member is coming for our membership, okay. So one idea you gave me here is
Right.
that while
Giving them the
delivering them
Template.
certificates, I can
Yeah.
include my TAMs and other credentials which I want them to, promote my organization. So that one thing, thank you for that. Okay, next Pooja, please continue.
Any updated version you would have an opinion on for enforcing contract? Not the conventional way. Maybe some other way apart from the conventional way, which cross-border nations can do via emails or maybe.
Yeah, that is something like I was just thinking of that when Madam said I gave you an idea. That this very thing came to my mind. Like, okay, when people are not comfortable having a written agreement, or they don't want to sign the contracts,
Right.
they could actually have something like a Zoom meeting where they come face to face, discuss the terms and conditions, and they have somebody else with them as witnesses also of both the parties, and the entire recordings are saved for any future dispute. So that is a very good, technology can be used for legal purpose also. It would be a very good evidence even in courts or even for the ADR mechanism.
Okay. Because that is what happens is when generally people reduce anything in writing, there is a fear care who is not trusting each other.
Yes.
So we do it so that both of this, like their interest will be benefited. But those two particular people, they are more concerned, Kari, why are we doing this?
Yeah. We trust each other, then why do you need it in writing?
Need it in writing. But we are doing it for their own benefits, so that the conflict doesn't arise. So this is the reason I wanted to ask that apart from this, video conferencing might be like a very informal thing, but it can be used as an evidence also in court.
Yes.
No,
And we
video
could have pinpointed questions saying that this is the way, okay, what is the jurisdiction or yeah.
Hopefully communicate in their own language, or
Yes. Yes.
that will be quite friendly discussion maybe.
Yes, friendly discussion.
Legal.
Actually, in Syria, we have, you can say, the same culture. If you ask the parties to write their agreement or their contract, they will tell you there is a confidence, there is a trust between us.
Right,
No
right.
need for that. So what I answered and what I replied to this idea, or I said, if there is no confidence between us, we will not make an agreement if it was written or oral or not written. Means I know already there is a trust and there is confidence between us, but the writing of the agreement, writing of the contract, they have another job, not about also it is a separate thing, completely different thing from the confidence or from the trust. So this is they have to convince me. What mom said also, it's very important, the parties to the contract. But we can say, if we can say, people at the public level should have knowledge about legal issue. If they didn't study law or they have not interested in legal studies or legal science, so that is very important for daily life. So you should have some experience, some information, some awareness about about their own legal issue. This first thing, and also what Mr. Nant said. I'm sorry. What said about the arbitration clause or arbitration agreement should be written. Also, this is very important, and this is compulsory. To arbitration agreement or arbitration clause to be written, this is compulsory. To written, and as I said, written and contract is not compulsory as principle, but arbitration clause is compulsory. Wow. Why that is very important to understand? Because when the parties of a contract, including arbitral clause in their contract, or sign an separate agreement, including
Arbitration.
the agreement to resort to arbitration. In this agreement, what they do, they are giving up the control of the governmental, we can say, governmental courts, official courts, from deciding over their dispute. And this way, they giving up their right to resource to the official court. And they are, after this agreement has signed between them, they are enforced to resort to arbitration.
Right.
So this is very important. And as I told you, I was teaching international arbitration law in Indian arbitration law to my student, and I pay their attention about this point, because even if they are students, 21, 22 age, but maybe making contract, sign contract, making legal work or something related to that. So first thing I do, I pay their attention about this point. When you include arbitration clause, or when you sign this separate arbitration agreement, here you should know what the meaning of arbitration, what the right you will own, and what the duty you should perform.
Exactly.
Sign an arbitral agreement means you can't resort to the official course to solve that dispute arise from that particular contract or particular business.
Okay.
Karim,
Yes, sir.
Rupali ma'am was suggesting that the parties can discuss over the terms of contract orally over Zoom meeting and video conferencing. If that is reduced into this, that is recorded, that becomes a means things which could be proved before the court.
Yes.
And even otherwise, courts, when the contract is unwritten, courts or if it is if it doesn't come before arbitration, usually unwritten contract doesn't come to arbitration, but the courts interpret what parties meant, what parties wanted to perform, each other's role and everything. Court interprets from the communication and the dealings. So that is again falling back to the conventional. With video conferencing, provides an added edge, you can record it rightly. Yes. What Jafar was suggesting is perfectly right, that there has to be a written contract for the purpose of arbitration. Then we can convince them that it is better in case of dispute, written dispute resolution mechanism being made available is better for all the parties, and it is mutually trust building. What Jafar was saying is already there is mutual trust, and therefore the parties are sitting across the table and making huge dealings of billions of dollars or whatever, and that mutual trust is there, and therefore to further build that trust or fortify that mutual trust, you have to reduce into what writing what has been agreed. That's it. It's nothing to be feared of or something. It's nothing something which is not known to anybody. It is already decided by the parties. You are just what is your writing it down. That's all.
Okay. What is necessary is necessary.
Yes, it's necessary. And it is beneficial actually. It's helpful and beneficial, and it provides a remedy. Then that is obviously parties would happily should agree for that.
Okay. Mr. Jafar, do you have any questions to ask our respected arbitrators?
No, actually, like not a specific question, but we can say an idea about, like, I am thinking, because I like specialize and I make a lot of research, or not, I mean several research publication articles, research article and publication regarding the international arbitration law and other method. I am thinking, like, always this idea come, we can say, to my mind. I think about it. This idea, like, if we are talking about alternative dispute resolution, we have four methods: arbitration, mediation, conciliation, and negotiation. I am thinking about how how much we have possibilities to create new alternative dispute methods, more than only these 4 types.
Okay.
So I think like if we can discuss about this issue, because these 4 methods or these 4 types,
Hmm.
they are similar in some points and they are different in other points. I mean not every type completely similar to another type. Every type has
Hmm.
its own we can say advantage or it is own characteristics. So this is that like if we can, like we have always this idea come from that principle which I believe in. Always we have to create.
Hmm.
Always we have to create. So I'm thinking about how much like we can create a new alternative dispute resolution methods.
Okay.
I
Okay.
don't know if like it is suitable to discuss this point right now or to postpone to another time. So, but this idea always come to my mind, and I wanted to share with uh, Sir and Mama.
Okay, about this, introducing and giving your idea about a new method of ADR. So we can have a, one-to-one discussion, Mr. Jafar. Okay, because this meeting is going to be uploaded to see our members, to see our other audiences as well. So about this method, I will coordinate with you one-to-one. And if there's anything to have suggestion from both the respected arbitrators, I will for sure inform them as well. Okay, so Ms. Pooja, do you have any further questions?
No, that's
Okay, Mr. Anand Chaure and Ms. Rupali ma'am. So, ma'am, both of you, thank you very much for joining us for this session. Okay, it was a very insightful and a very engaging session, and it would be more valuable to our members. Okay, because every time there are certain questions, whenever I ask them, put on this clause, this will be so beneficial. These are the advantages, so and so and so. So there are so many of various questions like I have to repeatedly answer. So I'm now more very clear to what words I can use or what in more clear ways I can explain them. So thank you so much, all three of you, Mr. Jafar as well. Thank you so much for all to join with us. Okay, and I hope that our members, if any question arises after this video, then I would request my members as well to kindly, email us, or you may even call us at our chamber days. So, okay, so we are all, because we are always ready to, support our and guide our exporters and our members. So whenever any question arises to all the members, then you may for sure contact us. And thank you so much, sir,
Thank you so
ma'am.
much.
Thank you so much for
Yes,
joining us.
welcome.
Okay, it
Always.
was a very
Really
Thank you.
insightful
For the
session.
opportunity.
And we
Thank you
shall
for giving us this
further
opportunity.
continue to do so. We shall further continue to frequently set up an AMA session. This was series 1. Now
Sure.
another topic will be informed to you very shortly.
Sure.
Okay,
Sure.
thank you so
Thank
much.
Thank you.
so much.
Thank you very much. Thank you very much for the.
Thank you.
Thank you. Bye bye.
Bye.
Thanks so very much. Thank you.
Thank you.